Right out of the gate, we've got Mr. Batiste facing not one, not two, but 3 separate criminal cases. One's for marijuana possession, but the other 2, first-degree murder charges. And here's the kicker. His prior convictions are going to crank up the minimum prison time if he's found guilty. We're talking a floor of 15 years. No parole-friendly minimums here.
Second, Mr. Batiste, in cause number 24, DCCR 0407, charged with the state jail felony offense of possession of marijuana from October 14th of 2023. And what that means in that case is if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in prison. Do you understand?
Yes.
So again, in 24 DCCR 0917 and 0918, you're charged in each of those cases with the first-degree felony offense of murder from January 10th of 2024. The indictment in each of those cases alleges that you were previously convicted of robbery, a second-degree felony, October 26th of 2018, and also unlawful possession of a firearm by a felon on that same date. And what that means in those 2 cases is that if you go to trial and you're found guilty, the range of punishment would be enhanced. The minimum punishment would be 15 years in prison up to 99 years or life in prison. Do you understand? And then in all 3 of those cases, I have here on the computer some documents, the plea bargain rejections that you've signed with Mr. Gertz, that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And it looks like the agreement...
This is what lawyers call a plea bargain crossroad. The state is offering Batiste a deal. Plead guilty to the murders and the drug charge. Serve 45 years total and avoid the risk of a life sentence. Reject it, and he's rolling the dice in front of a jury that could lock him up until he dies. Question is he feeling lucky or defiant?
Would be for a 45-year term in the institutional division of the Texas Department of Corrections in the 2 murder cases, and I guess a 2-year term in that state jail felony that would run concurrently. All of them run at the same time. Do you understand the possible consequences if you go to trial and what your options are if you wanted to enter pleas of guilty? And do you want to reject those offers and have all of your cases set for trial? Okay, we'll get those cases set for trial. Obviously, if there are any pre-trial issues or legal things that we need to take care of prior to...
Sorry, give me just 2 seconds, Judge. Sorry, just to clarify, he was concerned because you said both of the priors were on the same date, and I said that was the date he was sentenced, not the date of the allegations.
Okay.
I was just clarifying that.
Okay, the convictions were from the same date.
And I was clarifying too that it's better that if it were
True.
separate days.
Right. Okay, so you want to reject those offers and have all of your cases set for trial, is that correct? Okay, then we'll get it set on the trial docket. Obviously, if there are any legal issues that we need to take care of ahead of time, get whatever you need to filed so that we can take those up prior to any trial date. That way there's no worries when we get to a trial of going forward or not.
Yes, ma'am.
And
All right.
Judge, I don't know if Mr. Coleman has decided on behalf of the state if he plans to try both of the murder cases together. The marijuana is a totally separate incident, and whatever happens with that is what's
I
going
don't
to
think
happen.
that's the concern.
But I just want to...
Enter Tyron Henderson, a man already on probation in 3 separate cases. Probation is supposed to be your second chance. But Tyron's racked up new arrests, missed community service, ignored curfews, and fallen behind on payments. And one of those new charges, evading arrest in a vehicle. Not exactly the kind of thing judges overlook.
The state intends to file, if we haven't already, a motion to consolidate these 2 cases.
Okay, you've already filed it.
Okay. Good.
Okay.
So we would anticipate trying both of them at the same time.
Perfect. Okay, sounds
Okay.
good then.
Thank you, Judge.
All right, you may go back with the bailiff.
Thank you, Judge.
Thank you. Good morning. Are you Tyron Henderson?
Yes, ma'am.
And Mr. Henderson is on probation in 3 cases. In cause number 23 DCCR 0899, on probation for theft of property. In cause number 21-38934, on probation for evading arrest or detention with the use of a vehicle. And then in cause number 22-39131, on probation for unauthorized use of a vehicle. There have been motions to revoke filed in all 3 of these cases. Mr. Rennick has filed motions asking that I set bonds. Okay, So the theft of property is a straight probation. These other two are both deferred. So just by the nature of looking at the dates, without getting too far into this, it appears that he was on probation for the evading and the unauthorized use, and then received another probation while he was on those for the theft of property. Is that correct?
That's correct.
And those other ones were continued
Yes, that's right.
after that violation. Okay. And there are no bonds set at this time. Mr. Smith, I'll get to you, Mr. Rennick, real quick, but what is the state's position on bonds?
The only concern I have, Judge, is the fact that he is on probation and committed a new felony offense. In fact, he committed his own probation, got deferred, has committed a new offense.
So in the
Enter Tyron Henderson, a man already on probation in 3 separate cases. Probation is supposed to be your second chance, but Tyron's racked up new arrests, missed community service, ignored curfews, and fallen behind on payments. And one of those new charges, evading arrest in a vehicle. Not exactly the kind of thing judges overlook.
those motions, the allegations are, one, a new arrest for evading arrest or detention with a vehicle, an arrest for reckless driving, both of those from March 23rd of 2025, failure to provide verification of community service, out past curfew at 3:35 a.m., behind in his fees, and restitution. All right, do you want to call your client?
Judge, I don't want him to justify.
Okay.
About the thing. It's just basically our position is that he has a home structure. He realizes he's messed up. He realizes he hasn't ever just been probation. We're just really asking the court to set a bond. He doesn't want to show the court that he can comply with probation, get his classes done, his hours done. He has 3 clients.
I'm not worried about classes or hours. I'm worried about the fact that you're still getting arrested for the same thing that you're on probation for. And you've already been put on probation and given an opportunity. You violated the law. You got another opportunity, and I continued you, and now there's some more violations. Based on those, and I'm taking judicial notice of the court's file, includes the motions, the administrative hearings. At this time, I feel that it isn't, especially with the nature of the offense alleged and what he's on probation for, with an evading with a vehicle, which is, it's dangerous. You could hurt somebody, you could kill somebody, you have officers out there. Anyway, I'm going to find that it is in the best interest of
Judge drops the hammer. Note bond. Translation, Tyron stays locked up until his case is resolved. Why? Because he's a repeat violator who's shown he's willing to commit the same crime he's already on probation for. In legal terms, he's not just a flight risk, he's a reoffense risk.
the community, that there be no bonds in any of your cases. We will set these for whatever y'all want to on an announcement. If he's going to plead not true, we can have a hearing first on the motions and then move forward on the trial later if that's the...
Judge, with that room running into is to try to Mr. Smith and speak and see if there's something to work this out quickly. So
Okay.
just get something figured out as quickly as we
Okay, sounds good. We'll do a normal reset at this time. If something happens prior to that, just let me know. We can always move it up. You can go back with the bailiff. All right, sir, are you Lentavius Strickland? And Mr. Strickland, you were previously in court, entered pleas of guilty to evading arrest or detention with the use of a motor vehicle, as well as unauthorized use of a motor vehicle. I've received the pre-sentence report and reviewed that. Has everyone had an opportunity to review that?
Yeah, Your Honor.
Stay has, Judge.
Are there any additions or corrections?
Not from the state, Judge.
In addition to that, I have reviewed your jail incident reports. Everyone's been given a copy of those as well. Have y'all both had an opportunity to review those?
Yes, Judge.
I have, but I don't remember.
4 fights.
Yeah.
Oh, yeah.
You like to fight, don't you? You don't? You don't? Okay. I can tell you that I have people in front of me all the time, and they're not doing what you're doing. Constantly fighting. And the way these reads, it does not necessarily show that you weren't the aggressor. It doesn't show either way on some of them, but it looks like these were some pretty mutual things going on. Specifically finding places to fight, getting in the bathroom to fight so you can't be caught, and all that kind of nonsense. How old are you? 19 years old. So here is where I am on this. I understand that you guys had agreed to the 180 days up front. I don't know that jail necessarily is as useful as potentially something like ISF cognitive track.
Now we meet Lentavia Strickland, just 19 years old, but already with convictions for evading arrest and unauthorized use of a vehicle, and the jail reports. 4 separate fights. Not great when you're about to be sentenced and the judge holds your future in her hands.
Because of his age, nature of the offenses, and what's going on in jail. The only way I'm going to go along with this agreement is to try to get you in a better place to make better decisions so that you can be successful on these probations. I want you to be successful. We all do. But at the rate you're going, you're not going to be. The conditions of your probation are always up to me, so I can give you what I want as a condition, anything that makes me feel like it would be helpful for you, helpful for the community. So what I'm going to do at this time is find that you previously entered your pleas of guilty freely and voluntarily, and cause number 24 DCCR 2440, find sufficient evidence to find you guilty, and at this time follow your agreement and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with that agreement to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. In cause number 25 DCCR 0209, find sufficient evidence to find you guilty, and at this time follow the agreement, find you guilty of unauthorized use of a vehicle, sentence you to 2 years in the state jail prison, but probate that. You'll be on probation for 5 years in that case. I don't have a fine. Is there no fine in that one? The 1,000 and the others probably.
There was just one fine.
It was just
Okay.
one fine in one case, Judge.
Okay. So in each of these cases, you're ordered to follow all of the rules and conditions of probation. One of those conditions is going to be that you enter and successfully complete the cognitive track of the ISF program. It's a 90-day program.
The judge gives Lentavius a lifeline probation instead of straight prison time. But, with a strict requirement, complete the ISF cognitive program. Think of it as prison boot camp for decision-making. Fail it, and he's instantly serving his full 10-year and 2-year sentences. No appeals, no excuses.
It's in custody. You'll be transported from our jail to there fairly quickly. It's all about making better choices. Okay, so it's just to give you the tools you need so that you can be successful on this probation and not end up back in here and then going to prison. Do you understand? If you get in trouble now that you're on probation, if you get in trouble in the jail, get in a fight, if you get in trouble at ISF and you don't successfully complete it, you're going to already be in violation of your probation before you ever get out. So you need to figure out how to just stick to yourself, follow the rules, do what you're supposed to do so that you can get out and not go to prison, okay? All right, I'm handing you, and if you do everything you're supposed to, then for all practical purposes, your case here in court's over. You're going to serve those sentences while you're out on probation. But if you violate any condition of those probations, you'll be back in here and you'll be looking at the 10-year sentence and the 2-year sentence that you already agreed to. Do you understand? Okay, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker, okay? Good luck to you, sir. Take advantage of this opportunity. You can go back with the bailiff.